Hi, welcome back to our YouTube channel. I'm your host Abhishek Saxena, and it's an honor to be once again joined by CA Pradeep Modi sir, a practicing chartered accountant with over 36 years of expertise in taxation, corporate law, succession, and financial advisory. In the second episode, we will be addressing a subject that's becoming increasingly relevant in today's globalized world, that is, cross-border succession, wills, and property laws. Through this discussion, CA Pradeep Modi sir will be simplifying the challenges, opportunities, and practical solutions for individuals and families managing estate across borders. Hello, sir. How are you?
I'm fine. Good.
Okay. So, sir, let's dive to the questions. Should a person with cross-border assets make one will or separate wills for each country?
Very tough question. I congratulate you for this because normally people have idea that person who is living abroad, because we have seen in first episode we have addressed the questions related to India-centric assets.
Yes.
Now person is a global having a mobility, and therefore he travels across the globe, he invests the money across the globe, and he has a movable and immovable properties across the globe.
Yes.
Size may be a different depending upon the person's capacity to make an investment, but the movable and immovable properties are scattered across the globe, and therefore he is thinking that if I can prepare one international will, whether that will be a sufficient instrument for my giving a wishes to my beneficiaries as per my wish or not. But it is not true as far as the India is concerned.
Yes.
It is true for some other countries who have signed the agreement called a unit rights. So unit rights is the agreement which is signed by about 20 countries, came together, almost 16 or 20, I'm not sure.
Yes.
But there are a number of countries that have signed this agreement.
Okay.
If you are a part of that agreement, then yes, one international will can be accepted by all the countries who have signed.
Okay.
But India is not a signatory to that, and therefore it is always been advisable to prepare a separate will, number one. Number two, the will has to be prepared country-wise. Immovable properties, of course, will go according to the locations where it is located.
Yes.
But movable properties, yes, it has to be prepared country to country, and the court will pass the necessary orders of respective countries, and then it will go to the successions.
Okay. Okay, sir. So, sir, now as we're talking about the wills, so can you please tell us what is will?
Will is the legal documents declared by the person's intentions and for the disposition of their wealth or estate. So it is nothing but a wish list declared by the deponent, the person who is writing it on a piece of paper, and it is called a legal instruments which will give the rights to the successor to hold the properties in his or her name.
Okay. Sir, what is probate?
Probate, well, as far as India is concerned, the probate is issued by the court, and which certified the will, put their seal on that particular piece of paper, the will. It says that this is the only document which gives the rights to the beneficiaries to hold and receive the estate.
Okay.
But it is not applicable to the whole of the countries. But if your assets is located either in Mumbai or Chennai or Calcutta, only these are the three places. If the properties are located and situated, you have to go to the court and receive the probate, that is the order sealed by the court for a validity of the will. Then once the probate is issued, there will not be any challenge to be entertained by any other courts in the India as far as the will is concerned.
Okay.
But it is only when the immovable properties are located in these three jurisdictions.
Sir, is a probate of a will always required in India?
Not always required, because probate, I told you very specifically that only if it is assets are located in these three jurisdictions, three metros, Calcutta, Mumbai and Chennai, then only it is applicable. Otherwise, suppose for example somebody is holding the assets, let us assume somebody is residing in Ahmedabad, and holding the assets in Ahmedabad, he doesn't require the probates. Normally, there is a misnomer that probate has to be secured from the court, but as per the law, probate is only to be secured if your properties are located in these three metros only. Otherwise, not applicable. Even property located, let us say in Delhi or in any Cochin or any other place, Bangalore, there is no need of any probate. But suppose somebody is residing in Bangalore and having a properties in Chennai, then that will has to be get certified under the probate process by the court. Because his residential status may be in the Bangalore, but property is located in Chennai, then he has to receive the probate from the court. And Suppose the Bangalore having the same person, no property in either of these three places. He has a property or she has a property in Bangalore,
Yes.
and one property is in Ahmedabad and one property in Delhi. He doesn't require a probate because property is not located under the prescribed jurisdiction. It's a British law. I don't know why it has been continued. That must be required the redundancy of this act particularly.
Yes.
So government should look into this. But as on today, the law is there, and therefore we have to secure if the properties are situated in these three jurisdictions.
Okay, sir. Sir, how is a foreign will executed in India?
Foreign will basically can be executed in India by giving that copy of the will to the court, or probate of that country will be given to the Indian court,
Okay.
and that probate will be endorsed by the our court, which is called a letter of administration.
Okay.
So our court is in that case will not issue again a probate on probate or will to be certified as a true, but it will issue a letter of administration. So foreign will can be administered in India based on the letter of administrations.
Okay. Sir, what is the difference between probate and letter of administration?
Good. Probate is being issued on a will and it certifies the will,
Yeah.
while the letter of administration certify the foreign country's will, and therefore the difference between these two is that it is an order of the court in first place in case of a probate, and that is putting a seal on the will. In case of second options, when it is a foreign will, the court is issuing a letter of administrations. So that is not certifying the will is right or wrong, but they certify that it is a true, it is received from the foreign countries. So this is the difference between these two.
Okay. So does Sharia law apply to non-Muslims in countries like UAE?
Answer is yes, answer is no, depending on the person who is holding the assets.
Okay.
There are three jurisdictions in UAE also, where if you execute your will, if you write your will, then that will can be registered with the three different authorities there. And then, because otherwise Sharia is a forcip, we have seen in first episode,
Yes.
that it is the forcip rule will be applied. Sharia is nothing but a forcip rule.
Okay.
So automatically it goes the distribution of the assets according to the law written in particular piece of legislation.
Okay.
But in this case, if you want that I want to distribute certain assets which are located in UAE, then you should prepare a will without fail, and we will also get it registered in UAE at respective jurisdictions. And out of these three jurisdictions which are being prescribed in UAE,
Yes.
if you get them registered, then it will go according to your wish. Otherwise, under the Sharia, it will go under the forcip rule.
Okay.
So it's partly true that in UAE, yes, it will go according to the Sharia law in forcip rule. But if it is having a will registered in the respective places or respective jurisdiction which has been carved out, because Sharia is covered under the civil law,
Okay.
and will, if you want a freedom of writing something, is covered under the common law. So
Okay.
therefore, the UAE is created the jurisdiction within the jurisdiction.
Okay.
And that, for example, DFIC is a jurisdiction where you have to go and register your will, or RAK where you have to go and register your will. If you register this,
Yes.
you will definitely have a distribution of the assets in your absence according to the will.
Okay, that's interesting, sir. Sir, do Indian residents have full freedom to prepare their wills as per their wishes?
Yeah, it's obvious because we follow the common law,
Yeah.
and therefore the Indian citizen or Indian resident has a full freedom. The Indian domiciled person has a full freedom to write a will, and it will be distributed according to the wishes.
Okay. Sir, which countries require a probate or certificate of inheritance?
There are a lot of countries.
Okay.
Lot of countries. When we are talking about that properties in India required if the immobile property is situated either in Chennai, Mumbai or Kolkata. In this case, there are a lot of countries. For example, the Singapore required probate, USA required the probate, then UAE required the probate, France required the probate, Switzerland required the probate, Germany required the probate. There are so many countries.
There are, yes.
They required the probate, and probate is to be secured from the court.
Okay, sir. Sir, my last question for this episode will be, what is a transfer interviews?
Transfer interviews, it means that during the life interest of a person, it means that when he is surviving, if he gives certain gift to the someone
Yes.
as per the wish, so nothing is left out after he is deceased.
Okay.
in that case it is a intervivos. So during the lifetime something is given. Suppose Mr. A establishes the trust during lifetime, and under that trust the interest is created in the name of the beneficiaries, or some gift is given to somebody. In that case it is a intervivos, and where the will be applicable because already the transfer has taken place.
Yes.
So these are called the intervos.
Okay. Thank you so much, sir, for answering all these questions. That is all for the second episode of Cross-Border Succession, Wills and Property Laws. We'll come back with more questions on this topic in the third episode. Thank you so much for watching.